And in that case, they were able to actually dispute that, and with the help of a good lawyer and a group like Cirrus, and those landlords backed down, and they were not required to pay any of that in the end.
Eric, isn't there one of the big landlords who, when they send you an assignment letter, they automatically ask for the assignment fee to be 3.5% of the purchase price?
It depends.
I won't mention the name.
Yeah, exactly. Thank you. We've got our
landlord
online, but yeah, I mean, look, we do see that some more than others have taken a much more bullish approach. Look, if you're the landlord, think about it. You've now found a way to increase your profitability without a penny of additional cost, all off the back of yourself, the dentist. How is that possible? Right? How the blood, sweat, and tears that you've spent 20, 30, 40 years, right, in developing, right, the chair side, the stress, the threats of litigation, the patience, the headaches, the staffing issues. And at the very end, the landlord says, you know what? I want 5%. I'm going to take 5% off the top. No problems? Okay, great. It's so invigorating that perhaps why more people haven't heard of it from your colleagues is because there's a sense of embarrassment as well. Right, but at the end of the day, as Barb mentioned, imagine going through the whole process, and at the 11th hour, you've got a buyer right on the line. You spent months, you finally got everything all worked out, all the legal costs, and suddenly then the landlord throws you a curveball. Unfortunately, more often than not, right, the seller absorbs it. Right, and yes, we just had one the other day. It was over $120,000 that to facilitate that sale, they had to pay that to the landlord just for the assignment of the lease. So yes, it is an absolutely devastating component. And what's the landlord's approach? Hey, right, what's your practice worth without my space? It's my space that's right. It's my foot traffic. It's my space. It's my location. If not, what's your practice worth without it? Right. So that should, if nothing else, send anger through each and every one of you. And as a great reminder as to why it's so important that these type of things be corrected and amended. Right? Obviously, they didn't write these leases to just go after a dental practice sale proceeds, but it doesn't stop them from using that. Right? They're trying to prevent a tenant from profiting through the assignment is the intent. But as we know, that can get blurred. In the essence of time, relocation and demolition, I didn't want to skip over this too much because as you may have seen in some of your valuations, it can be upwards of $250 per square foot of a reduction of value because of a relocation and demolition clause. I'm pleased to report that we deal with these every day, from the largest multinational REITs to the smallest mom and pop. And we have found many ways, especially with runway and time, to be able to either amend or remove these types of clauses. So again, because we've done 13,000 of these, we've got history, we've got precedents, we've got great relationships with the landlords, and we've been able to, again, educate the landlord as to why these types of things can be damaging, and to help ensure that we have clarity, especially if the buyer cannot get approved by the bank because of these demolition and relocation clauses. So bottom line, there always can be a solution, but it does take a lot of time, unfortunately, energy and effort in order to rectify these and to make sure that things are corrected for you. Personal guarantees is another interesting one, and continuing liability. A lot of doctors only find out too late that, and unfortunately, it's cost a few sales recently, where suddenly the seller becomes aware that the landlord's not going to let them off the hook, and hidden in Article 76 subsection 2 in the assignment clause, that regardless of the landlord's desire or the ability to them to assign the lease, you as the original tenant, personally or corporately, can remain continually liable even after the sale. So those are all core components to be aware of. One little practical example I thought I'd show tonight is in the assignment clause. And this is one we can quickly run through together, right? We won't let the lawyers jump in and give the answers before anyone else, but ultimately that assignment clause is one of the first things that Barb and Anthony and Kelly will look at through the valuation component to ensure there's nothing here that can prevent or cause a surprise, shall we say. So before I pass it off to some of my esteemed colleagues here, take a quick 30 seconds to look through this. And this is found in about 75% of dental leases, and see what you can determine in terms of a red flag. And for those of you that are following along with your lease and you're not sure, I put up the email at the bottom as well. Now, usually when we're in person together, I say, and who loves reading leases? No one ever raises their hand. I get to do it all day, every day. And it's, once you know what you're looking for, it can be helpful. All right, this is interesting. So basically in every lease, you cannot sell your practice without the landlord's prior written consent. So look for this in typically the first sentence of the assignment and subletting provision within your lease, number one. Number two, right? I do. Okay, perfect. Dr. R, thank you. Number two, look at this. So you've now asked to sell your clinic. You've gone to the landlord, you've negotiated purchase and sale, everything else is done. You've gone to the landlord, and the landlord now has three options. Number one, green light. Perfect. You're good to go, right? We can now, I approve of Dr. Smith taking over your clinic. Number two, no, I don't like the cut of Dr. Smith's jib. No, I'm declining that. Or number three, the landlord has the right to terminate the lease upon the effective date of such proposed assignment or sublet. So putting that into other words, right? Not only can they tell Anthony not to go golfing tomorrow, but they can take his golf clubs and throw it into the ocean. Little golf analogy for this evening, Anthony, right? To keep everybody on their toes. But this is disgusting. Look at it. This is the landlord's ability to not only say no, but to say no and terminate the lease the day you're planning to retire. The landlord now has the opportunity to tear up the lease, right? Terminate the lease, and quite frankly, engage directly with the buyer. Right? Imagine the buyers now, right? How much more would the buyer be prepared to pay in rent to engage directly with the landlord and skip over you as the seller? So it goes without saying, this is one of the last things that Barb and Anthony and Kelly that want to see within your lease, because it just gives too much control at the 11th hour, right? And all it takes is the one landlord to say, yeah, I'm not too sure, right? And instantly they found ways to dramatically increase their profitability. This is another great one. Landlord shall have the right to revise the minimum rent paid during the remainder of the term to the greater than the then current market rate, right? Or 15% greater. Again, if you're the buyer, you've gone through the whole process, all the full valuation, yet suddenly the landlord comes back at the 11th hour with a, you know what, you've been underpaying, and I did it for you, but you know what, for your future buyer, market rent's gone up. Inflation, oh my gosh, inflation. Here's a 15% bump, congratulations. If I was a buyer, I'd run for the hills, right? And then last but not least, this was the consideration language we referenced before, right? Where again, the landlords can use this, as they are more often, to receive a percentage of practice sale proceeds. And of course, right, notwithstanding any of the contrary, the landlord, the tenant, shall not be released from its obligations under the lease and shall remain fully liable for any failure of the tenant or its assignees or subtenants. So that's not just rent. If you've sold, and we had a bunch of this through COVID, right? If the doctor sold 3, 4, 5, 6, 7, who knows, years ago, right? That doctor might be shocked to know that they are still continually liable as long as that future doctor is continuing, and that's still the governing lease, and still remains continually liable and potentially personally liable as well. So one single clause here, right, can obviously have hundreds of thousands of dollars of impact. So to summarize, and I promise to keep things brief, is this is the solution. This is actually the similar slide to what landlords teach other landlords. This is the tenant lease cycle. This is the wisdom to how they create a playbook, again, to maximize their profitability off of you, their tenant. So what we're looking at here at the very top is a 24-month cycle, right? The best time to start lease negotiations are at least 2 years, even with COVID now, especially if there's no further options, maybe even 2.5 years prior to expiry. That gives you the most leverage. Why? The landlords know that it can be upwards of 18 months to 2 years to relocate a practice now in the GTA, permitting, build outs, right? Supply constraints, chip shortages, right? You name it. So what do landlords do? Oh, it's too soon, I'm delaying, right? Suddenly it becomes 12 months out. Well, without knowing it, hidden in there, 9 months prior to expiry is your option to renew deadline. And if you miss that option to renew deadline, you might be surprised to know that those remaining 2 5-year options that you thought you had have just become null and void. Right? So landlords are taught to wait until the last possible second, right? Of which then 3 months prior to expiry, oh yeah, the lease renewal, no problems. Oh, by the way, it's a 15% increase. Sorry. Right? So I urge each and every one of you to be aware, right? And start with this simple process. 27 years, 13,000 successful lease negotiations, and it really does boil down to this. Number one, get all the information. You'd be surprised, Michael maybe not, Barb maybe not, but you'd be surprised how many doctors don't have a signed and countersigned from the landlord version of the lease, or in some cases, even an actual copy of the lease. So let it be taxes, let it be government incentives, all sorts of things. You can email your landlord right now and just say, please send me a digital copy of my lease, and one of their admins should have it back to you, right, first thing in the morning. So first of all, understand what's the original lease from 1987, what's any addendums, riders, exhibits, that have and renewals throughout the course of the term, as well as any assignments throughout the process. Number two, though, really work with your professional team, as we're seeing here tonight, to really think of your long-term practice and career goals. If you're the 11% that are looking to buy or build or expand, right? What does that exit look like? Don't go into a new venture without an eventual exit, right? Number three, have your lease professionally reviewed. Ensure you're aware of of what's in it, if nothing else, so that when you go into these processes, at least you know, yes, I have a demolition. Yes, I have a relocation. Yes, I know I'm not going to be able to sell my practice in this location because the landlord is, eventually at some point between now and 99 years from now, going to demolish it and put up a condo. Right? And without that predictability and continuity, it makes the practice sale virtually impossible. Number four, we have all the commercial real estate data, so rental rates, vacancies, comp reports, etc., plus the dental deals we've done in the area, right? Get the market research. Number five is determine that carefully choreographed game of chess, right? What do we really want to end up with after all the back and forth with the landlord, right? But please, what have we not done at this point? We've gone through steps 1 through 5. What have we not done? We have not yet picked up the phone, this phone, right, and called the landlord. So please don't tomorrow morning say, oh, shoot, my lease is coming up. Eric told me to start early, and pick up the phone and call the landlord. Hey, what do you want to charge me? No, don't skip the steps. I promise you it works. Then proper negotiations for the business and financial clauses, and don't stop until you get a great countersigned lease. So needless to say, in appreciation of time, if you do have questions, if you're not sure what within your lease, happy to schedule some time. I think I might have an exit poll for us as well, just to make it easy. If you'd like to schedule a complimentary consult, I know many of you I've spoke to personally. I know some of you are in a variety of different stages. But again, if your lease is in a month-to-month basis, if you are in a situation where you're just not sure, and would just appreciate the peace of mind of just talking about a little bit more about your situation, happy to go through, and just by clicking yes, we'll make sure that myself or my team, reach back out to you, schedule a quick time, and happy to spend up to an hour with each and every one of you discussing situations, strategies, and most importantly, how to make sure that we make Michael's life as easy as possible. and make sure it's a smooth transition for you every step of the way.
Thank you, Eric. We appreciate that. And speaking of Michael, we will now pass the floor to Michael.
Yeah, Eric, that was a really good presentation. I could pick your brain all day and talk about certain situations that we've seen with leases. I mean, Anthony and I closed the deal today that we had been working on for about 1.5 years. And obviously the big issue in that one was it was a chart deal because the landlord, who was one of the big landlords, it was downtown Toronto, said, we're not giving you any more renewals. And so she was sort of stuck selling charts, which, I mean, Anthony can speak to how that impacted the values, the practice. We ended up getting the deal done, but it was a chart deal. So, you know, obviously, Eric, I think you hit it right on the nose there. And I'd suggest to everyone listening, talk to Eric, talk to someone at Cirrus, and really get your lease in order to make sure everything is good. So Kelly, you did a great job of introducing the firm and me. So I'm the younger gentleman at the top, and then the gentleman to the left is an older version of me, also known as my father, who started the firm, and he started the firm back in the 70s. So he's been doing dental deals for quite a long time. And then to the right, you have Mitchell Wong, who's another lawyer at the office. Mitchell comes from a family of dentists. His 2 parents are dentists, his sister's a dentist, and he's the black sheep of the family because he became a lawyer, but I guess he became a dental lawyer. So Kutner Law assists dentists within corporations, buying and selling of dental practices. We're probably doing about 20 to 25 dental practices at any given time, so we're quite experienced. This is probably the most important slide for you to look at, remember, and you know, I'm sort of echoing what Barb and Anthony had mentioned earlier in the presentation. Get the right team around you. Get the broker, your accountant, your lease negotiator, and your lawyer. Make sure you're comfortable, make sure you're getting referrals. You want to make sure it's someone who has dealt with dental practices in the past. Inexperienced team members can cause errors, delays that can impact or cause serious issues in a deal. Now, I know I've been working too much with Anthony and Barb recently because they were hitting all the nails on the head in terms of legal issues that come up in these deals. So I feel like they've spoken a lot about the issues that you see from a legal perspective, but I'm going to run you through some things to watch out for. Hopefully you find those helpful, and then you can ask me some questions later on. So just a roadmap of a typical transaction. Every broker does things a little bit differently. If you're selling to a DSO, it's a little different. If it's a private deal, it's a little different, but generally starting with the LOI, then the due diligence starts, then the purchase agreement starts, and then once everyone's happy and the conditions are waived, we can close the deal. The letter of intent is a 3-page document. Tier 3 has their standard version, which is perfect. It hits on all the right points, and it sets out the basic terms. It is non-binding, remember. It's not like a purchase agreement. Some of the other brokers will start with a purchase agreement that is binding. So you want to make sure your lawyer is reviewing anything that you are signing, whether it's binding, non-binding. That is important. The LOI is going to contain conditions. It's going to contain the purchase price, which from the seller is probably the #1 thing your eyes are going to go to right away. What's the non-compete, non-solicit that you're signing? You want to make sure that that's something you can comply with. The letter of intent will have an exclusivity clause, which means for a certain period of time, you can't discuss the sale or negotiate another sale with another buyer for a period of time. With tier 3, once the letter of intent is signed, we're going to go on to due diligence. But before I talk about due diligence, utilizing a denture professional corporation, I'm going to use the term DPC, short form. So just before you sell, if you're not incorporated, DPCs get taxed at approximately 13.5%, whereas dentists are taxed at approximately 54.5% at the highest marginal rate. That's a massive difference. Now, keep in mind, you have to keep the money in your corporation. If you're spending all the money you're making to fund your lifestyle, to buy the cottage, to do whatever, corporation's not going to help you on that end. But when you go to sell your practice, it's really helpful because you can get what's called the capital gains exemption if you sell. Right now, it's $913,630, and that's per person. That's a one-time capital gain. So if you're selling your practice for $913,630, that's all going to be capital gains tax-free. Now, if you're smart and you plan ahead, and your accountant's, actually your accountant and lawyer are smart, they'll advise you to add your spouse as a shareholder, and then you can multiply it ×2. Now, if you're really smart and you have children that you trust and parents that you trust, now you can multiply that even further. So, you know, if you add I did a deal recently for over $3 million. A couple of years before closing, we added the children as common shareholders. and they were able to sell the $3+ million practice capital gains tax-free. Now, keep in mind for spouses, children, you need to have them as shareholders for at least 2 years. There is a way, if you aren't incorporated and you plan on selling, you can incorporate and sell the shares right before closing. So if you're not incorporated and you have plans to sell, don't worry about it. The deal I was talking about that we closed with Anthony today, same thing. She wasn't incorporated. We incorporated, transferred the practice, and she was able to take advantage of the capital gains exemption. But if you have a massive practice, that's not going to help. So talk to your accountant, talk to your lawyer. How are you going to structure the deal? Is it going to be share sale or is it going to be an asset deal? Share sale, most sellers want to sell shares, and because we've been in a seller's market for so long, sellers dictate it. Purchasers generally want to buy assets. Less potential for risk. You're not buying the corporation if you're buying assets. You're buying goodwill, you're buying equipment, you're buying leaseholds, but you're not buying that corporation. If the purchaser buys the corporation, if the CRA, if you didn't pay taxes, let's just say, for example, the CRA comes back, they're coming back after that purchaser. Now, with the purchase agreement, you have certain representations, warranties, indemnities to protect the purchaser, but it can become a problem later on. Notwithstanding all of that, because again, we're in a seller's market, the sellers dictate how it's going to be structured generally. And if they can sell shares, the deal is structured as a share deal. Just one little point there, if you're selling to a DSO, a dental services organization, it's often structured as a hybrid deal, a mixture of shares and assets. It can be quite complicated, and so your accounting legal fees will be higher. But that is just, it has to happen like that. I'm not going to get into the nuances of why, but it is something that needs to be done. I always tell purchasers, due diligence is the most important thing you can do, part of the transaction. You don't want to find out an issue after closing that's going to impact you as the purchaser. Then you're going to go through litigation. It's going to be a lot of money. It's going to be time consuming. So doing the due diligence and finding out the issues, or whether you're just not comfortable with a practice, much better to do it at the beginning. From a seller's perspective, I have a lot of sellers who I would say become annoyed by the process, right? Even if you're selling to a DSO, it's they're really looking into things. But a general buyer, they're going to do their chart count. Their accountant's going to do their financial and accounting due diligence. They're just not going to rely on the appraisal, as good as it may be. The appraisals from information given by the dentist selling. A lawyer is going to review contracts. We're going to review the associate agreements, employment contracts. We're going to do searches. So we want to try to see if we can find if there's any litigation or judgments against the dentist. Have they gone bankrupt? Is there any bank debt registered? Barb touched on this. The Cirrus approved floor plans, make sure they're in order. I can't tell you how many deals I have that are being delayed. Cirrus in February changed their policy. They are no longer giving out the plans that they have on file. And so you've got to redo them, which is a huge headache and takes a long time. So once the due diligence is done, the purchaser's lawyer will prepare the purchase agreement, which takes a few weeks. I did close the deal recently where the purchase agreement took a year, which is not the norm. But a month or two to get a purchase agreement seems to be pretty standard these days. Barb and Anthony talked about representations and warranties. I'm going to get into that a little bit in a second. And then you're going to have your conditions to closing. So the big ones, your financing conditions. So the purchaser needs to get the financing approved. Eric, nothing else needs to be said about how important the lease assignment process is. That's the key. I have many deals on the go. I have one deal for a client who bought 6 years ago. He had 12 years left on the lease then. Landlord's one of the big landlords is saying, we need a demo clause if we're going to give another option. I have another practice where she forgot to renew her options, as Eric said, is a problem. And now we're at the mercy of the landlord in both situations to get that done. Representations and warranties. So as Barb had mentioned, you're going to be giving representations about your practice, your DPC, and you personally. The purchaser wants certain assurances from the seller that they can't discover on their own. If there's any issues with those representations and warranties, and I'm acting for the purchaser, I'm calling Paul immediately because Paul is going to have to start litigation against the seller, especially if the purchaser had suffered any damages. So one of the examples of that, if let's say a standard representation is the seller collects substantially all co-payments in compliance with all applicable laws. Well, if that turns out to be false, the purchaser can bring a claim for any damages. Did they lose patients? Was there an insurance claim after the insurance companies have decided not to deal with the practice anymore? Was there an RCDSO issue? All these issues can arise just from that simple representation. Assignment of a lease, I'm going to sort of go through this very quickly. Again, minimum 12 years, because the banks are amortizing their loans over 12 years. So any less than that, you could probably get away with 10 years, but then, your purchase price might be dropping because the amortization schedule is going to be lower. Eric, brought up a lot of horror stories. Personally, I'm finding landlords are making it more and more difficult to assign the lease and are reluctant to agree to many amendments. If you're at the end of the lease is the last thing you deal with in these transactions. And so that's when you find out whether the landlord's going to play ball or not. And often, if they are willing to play ball, they are asking for some money, higher rent. It's not so smooth. And to me, sometimes paying that higher rent, and in the example I'm going to say in a second, it is worth it because otherwise you can't sell your practice. So we did a deal for a seller downtown Toronto, and the option to renew language provided that the option to renew was personal to the seller. So it said if Dr. Michael Kutner is the tenant, then he has an option to renew, but it doesn't pass on to the purchaser. So we pleaded the landlord to assign that, allow that option to continue to the purchaser's benefit. And the landlord, who made a mention, is a lawyer, very difficult person to deal with, said, absolutely not. I'll do it for $100,000. And it was paid. And ultimately, it had to be done. Otherwise, we were selling charts for probably a discount of more than $100,000. Associate agreements, so important. And I'm talking about the associates you have in your practice. I get calls from associates all the time. I've been here for 10 years. The principal had promised me to sell the practice. He's not doing it. Well, I say, do you have a contract? No. Well, okay. And they say, well, can I open a practice down the street? Yes, you can. And what happens if the patients come and see me there? You don't have a contract. You don't have a non-solicit clause. You can solicit the employees, you can solicit patients, employees. There's really nothing preventing it. And as a seller, what you're trying to do is protect that goodwill. The purchasers are going to ask for those associate agreements to be in place. At the very minimum, a non-solicit in place. Non-competes are generally not enforceable anyways, but and the banks for a long-term associate are going to ask for that to be in place. Otherwise, there can be issues with financing. So definitely get those associate contracts in place. As the seller, you're going to be signing a non-compete, non-solicit, so be comfortable with what you are signing, okay? Obviously, the purchaser wants to protect the goodwill when they buy. So a time frame you'll typically see is 3 to 5 years after you're done your associateship. The radius is large enough so that the purchaser is comfortable that patients aren't going to move to the new dentist. I had a meeting with a potential new client today who was opening up a practice nearby and wanted to sell one practice. And I said to her, your other practice is 5-6 kilometers away. A purchaser is going to have an issue with that. So they're going to ask for a charge fee. If any patient goes to the other practice, they're going to want some compensation for that. So it can be a very heavily negotiated item. I know Barb and I just closed the deal a couple of weeks ago, and I think that was the longest restrictive covenant negotiation that either of us have been a part of. Just one note there, non-compete will be upheld if you sell your practice. Vendor to associate post-closing, one of the closing documents that the vendor will enter into is an associate agreement, if that is the case. Typically, you're seeing 6 months to a year. The purpose is to provide a smooth transition for patients and staff. That's generally the purpose. If you're selling to a DSO, it's going to be a longer associateship, 3 to 5 years generally. You're going to get your percentage of collective billings. That's, again, up for negotiation. And then your restrictive covenants will be incorporated in there. Paul Martin is going to talk to you about employees. If I have an employment issue, if I want employment contracts that I'm not sure of, reviewed, Paul Martin is the person. I mean, I've actually referred my own mother to Paul, so that's how much I trust Paul. So I'm not going to get too many details here about employees, but I always tell purchasers it's really important to continue the employees at the practice. So what you'll generally see when you do the transaction is the purchaser retain the employees on the same terms and conditions after closing. And that helps avoid the vendor having to terminate and taking that termination liability on. One clause you'll see in the purchase agreement often is that if the buyer terminates an employee within 90 days of closing, the costs are split equally. That's also up for negotiation. But if you have Paul put in proper employment contracts, you can certainly mitigate any future liability that you or the purchaser may suffer. Closing of the transaction. Once all the conditions have been waived, the lease has been assigned with the landlord's consent, financing has been arranged, and the purchaser is satisfied with the due diligence, the deal is ready to be closed. The lawyers draft standard closing documents. The bank sends the funds to the purchaser's lawyer, and the purchaser's lawyer sends it to me. And then once we're satisfied, yay, you get that money. Your lawyer will wire it to you. Just a few notes. I've talked about selling to a corporate entity. Dental Corp, Ultima 1, 2, 3. There's multiple other smaller DSOs from 10 to 50 practices who are very, very aggressive. One point, and I'd love to have a discussion with Eric on this. The DSOs aren't as concerned with the lease terms as a single dentist would be. They have practices everywhere. So sort of an interesting point on the lease. But if you do get a letter of intent from one of these DSOs, make sure your advisors are looking at it. They tend to be much more complicated. You want to make sure you're associating for a period of time you're comfortable with. You want to make sure those guarantee revenue formulas that sometimes you'll see with these DSOs are taken care of and are what you expect. They are quite complicated. You want to make sure your restrictive covenants are not overly restrictive. The corporations are flexible in terms of the structure of the transaction, so don't think you can't negotiate with them if you do get an offer. One thing I have seen in confidentiality agreements and the LOIs is that they try to get that exclusivity period. I've seen up to 6 months, which to me is a long time to be negotiating with only one buyer. That negates any opportunity you may have to say this isn't working and find another buyer for your practice. Is a DSO right for you? Talk to your advisors, talk to other dentists who have sold to them. Certainly from a legal perspective, a much more complicated transaction. As I said, it's a hybrid deal. They're looking at much more in-depth in terms of their due diligence. 5 biggest issues. So we have the lease. I put demolition clauses in there, but if you don't have enough term on your lease, 12 years, you're up to the mercy of the landlord. The no associate agreements, make sure you have your associate agreements in place. Your DPC not being properly structured before a sale. You're talking about hundreds of thousands of dollars in tax savings if you are properly structured. No employee contracts. It's not a hard thing to do to get those employment contracts in place. Hopefully your employees are not too difficult to deal with. And practices that are not being run in accordance with all applicable laws, you're not collecting co-payments, IPAC issues, all that can impact the sale. Make sure if you're thinking of selling, you're talking to your advisors several years, not less than I would say 3 years before you plan on selling, so that everything that can come up is fixed to the extent it can be. Not everything can be fixed, but we can do the best we can to get you ready for a sale. So thank you for taking your valuable time to attend the seminar. Please don't hesitate to contact me. My website, kutnerlaw.ca is there. My phone number, email is there, and I'm happy to have a preliminary conversation at no cost on a confidential basis. Thank you very much.
Thank you, Michael. That was really great information. And now to our final presenter, last but not least, we'll pass the floor to Paul Martin.
Okay, thank you. It's never the easiest thing to go last after so many great speakers, but I'll do my best. So my name is Paul Martin. I'm a lawyer as well, like Michael, but I'm a different type of lawyer than Michael. I'm the type of lawyer who comes in after deals go wrong. I'm a litigation lawyer. I don't do any of the type of work that Michael does. Typically, we're involved in matters where parties are in a dispute, and I try and focus in on several different areas of law. One of the major areas I deal with for dentists is employment law. We also do commercial litigation for dentists. So if you have a deal and one of these bad issues arises with a lease or with reps and warranties not being accurate, typically we would get involved and litigate those matters on behalf of dentists. And the other area that we deal with as a firm is we deal with matters involving complaints at the RCDSO and discipline matters at the RCDSO. So those are the areas that we try and focus in on for dentists. Today, I'm going to speak solely about some employment law issues. So what I want to do is I want to take 2 cases that have come out over the last year, and I'll give myself a shameless plug. I was the lawyer who argued them successfully in both of them. They're very important cases for employers and for dentists in particular. So what I want to do, I've over the years, I've been doing this for almost 15 years for dentists. I've flogged the dead horse, as they say, in terms of telling dentists, you got to get your contracts in place for employees. You have to get your contracts in place for associates. Barb and Anthony and Michael spoke about why that is important. Okay, it helps in terms of the way that you structure your deal. It also, of course, helps you on a day-to-day basis, because not only do you need your contracts in place for a potential sale of your clinic, but you need them in place to protect you in case something goes wrong in the course of the relationship. And so the contracts are good. What I want to do is take these two cases and focus in on why contracts are so important. Okay, so why you need them in the day-to-day running of your clinic, and certainly why you will need them in the sale. So I want to deal with first just the basic framework of employment law, is what I'll call it. When an employee is terminated from their employment, typically they're entitled to what's known as reasonable notice. Okay, and reasonable notice in the absence of a properly drafted contract can be up to a month per year of service. So if you've had someone working for you for 15 years and you want to fire them, then you're going to owe that individual potentially 15 months of pay. That's a lot of money. That's a pretty penny, as they say. If a contract is drafted properly, this entitlement can be limited. Okay, and this entitlement can be limited to what they call the Employment Standards Act minimum. Okay, and so under the Employment Standards Act, there's a formula for how much an employee is entitled to when they're let go. And that formula, it's a little wonky in the first 3 years of employment, but it flattens out to be a week per year of service, up to a maximum of 8 weeks. Okay, so the distinction between having a contract and not having a contract is a month per year of service versus a week per year of service capped at 8. So you take that same 15-year employee who is let go from your office, and instead of having to pay that person potentially 15 months, you're only paying that person 8 weeks. So that's why contracts are so valuable. Okay, and of course, when you're selling your clinic as it relates to employees, a potential buyer of your clinic is going to look at your staff members, and they're going to go through a list, and that list is typically a schedule to the LOI and certainly to the agreement of purchase. And they're going to look at your staff members. They're going to look at the contingent liability of each of those staff members, because while you may have been able to coexist with a staff member for 15 or 20 years, a new buyer is going to come in and they're going to want to do things differently. Okay, and I've seen this happen time and time and time again, where an older staff member who's managed to work in that clinic for a long period of time and may have been valuable to the vendor starts to butt heads with the purchaser after the purchaser takes over, because the purchaser wants to start doing things differently. Maybe they're not going to be as lenient with those longer term staff members as the former owner was. And lo and behold, you start getting friction in the workplace. And if the buyer wants to let that person go and they've purchased the clinic without staff contracts in place, they're going to inherit all of that previous years of service. So again, back to our hypothetical 15-year employee, if the new buyer wants to let that person go, they may be on the hook for up to 15 months. So that's why buyers of clinics will want to see contracts in place with staff members. They want to know that if they buy the clinic and they do start to butt heads with one of the staff members, they have an easy eject button that they can push. Okay, they can let go of that person and know that they have the comfort of the contract that has been transferred over to them as the buyer, and only have to let that person go and give them a maximum of 8 weeks. That's why contracts are important. And I've been singing this from the mountaintops to dentists for, as I said, almost 15 years. They are important. You should get them in place for the reasons that everyone else has alluded to previously. But what I want to talk about is some nuance with respect to contracts and why it's important, even if you have contracts in place right now, to pop the hood and have a look at what's going on. Because the case law with respect to contracts, employment contracts, is forever in flux. And there have been a number of landmark decisions that have come out over the last 10 to 15 years where the courts are really taking a run at these contracts. They do not like them, is the message that the judges are giving to employers. And courts will bend over backwards and use legal gymnastics to try and get employees out of these contracts so that the employee is not bound by that provision that says you only get a week per year of service up to a maximum of 8. And instead, the court's going to try and undo that provision and ensure that the individual gets that month per year of service. So while contracts are good, even if you have them, this is a very opportune time for you to have someone review them because of some of the changes that have happened over the last little while. I'm going to speak to the major change that has come out over the last 2 years, a decision that came out in June of 2020. It's a case called Waxdale. And I'm going to take that and build on it with a case that I argued last summer that shows the implications of not having your contracts looked at. So under the ESA, what you need to keep in mind is that there is not only the requirement to pay that 8 weeks under the termination framework, but there are other obligations under the Employment Standards Act. You may have to pay severance for dentists. That typically doesn't matter because this severance component only applies if you have a payroll of over $2.5 million. Most of my clients don't meet that threshold, but certainly they're out there. You also need to continue the employee's benefits for that requisite period of time. So if the notice period under the ESA is 5 weeks, you would need to continue their benefits for 5 weeks. And you need to make sure that all of the other protections are accounted for. The takeaway from that is that if you don't account for certain things in a termination provision that otherwise you need to account for under the Employment Standards Act, and therefore it results in a payment of less than what the ESA minimum is, then that termination clause that you have put in place that theoretically limits your entitlement or your obligation to that week per year of service could be invalidated. And when it's invalidated, the courts will award that individual that month per year of service. And I'd say there's been, off the top of my head, probably 15 to 20 cases that have come out over the last 10 years where the courts have done like what I've called legal gymnastics to get employees out of these termination provisions and to give them what they're otherwise entitled to at common law. The most stark example of that is a case that came out in 2020, the one I previously mentioned, this Waxdale case. So this case is one of the few cases that has left me and many of my colleagues scratching our heads over the last number of years, because the court went to such great lengths to take certain provisions in the agreement and utilize them to invalidate an otherwise perfectly enforceable termination provision that said the employee only received that ESA minimum upon termination. So what the court did in that case is they took a separate provision that was not part of the actual termination clause, a provision that said, we can also fire you for what's known as just cause. And just cause in employment law is the capital punishment of employment law. When you're fired for just cause, what it means is that you've done something so egregious that the employer can end the relationship and provide you with no notice whatsoever. And typically those cases are reserved for the most terrible of conduct. What I always say to my clients is you can't really fire someone for cause unless you've caught them stealing from you or committing fraud or assaulting someone in the workplace or sexually harassing someone in the workplace. Those are typically the types of behavior that will allow an employer to end the relationship and pay the employee nothing. If the employee is just a bad worker, is a little bit insolent or insubordinate or is not punctual, none of that is typically going to give you the ability to fire someone for cause. But in this case, what the contract said is we can fire you for cause and let you go and give you nothing. And then it listed a laundry list of behavior that they would purport to rely upon to say that they had just cause. And the court looked at that provision in the contract and said, well, hold on a second. Some of this behavior that you're outlining in the contract itself and saying that it would give you just cause to fire someone really wouldn't give you just cause to fire someone. And then they took that and they used the ESA again to invalidate the contract, because the Employment Standards Act also has a provision that allows an employer to fire someone and give them no termination pay. But it's a quirk of employment law, specifically in Ontario, because the other provinces don't have a distinction between the common law threshold of this just cause and the statutory framework of when you don't have to pay someone termination pay. The Employment Standards Act in Ontario has this oddity where they don't use the term just cause. What they use is the quote at the second bullet point. So if you want to fire someone and not provide them with their ESA minimums, that person has to be guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So the key term that's used throughout that definition is willful, because theoretically a situation could exist where you could potentially get away with firing someone for cause if their behavior was terrible over time, but it wasn't necessarily willful. And so what that creates this dichotomy where theoretically, if you fired someone, you might not have to give them that common law month per year of service, but you may very well have to give them at least their ESA minimum if the conduct wasn't willful. So it's this oddity of employment law in Ontario, as I said, that the court seized upon to say, well, what you've outlined in this contract where you say we could fire you and give you nothing may not constitute willful misconduct. And therefore, you're really breaching the Employment Standards Act because you're telling that person they're going to get nothing even under the ESA if they do something that's not willful. And so the court took that and then they made a massive leap of logic and said, okay, so now that clause is bad, that willful misconduct or the just cause clause. We don't like that. We're going to strike that from the agreement. And because that's so terrible, what we're also going to do is strike out all the other provisions that have to do with termination. And they took the bad just cause provision and used that to invalidate the otherwise perfectly fine without cause provision that said you would get 8 weeks under the ESA, resulting in a situation where the employee was entitled to that common law month per year of service. So this is the oddest case that has come out on this over the last little while. I argued a case last summer on which is an extrapolation of that Waxdale logic. And on this case, I acted for the plaintiff, Dr. Livshin, who was employed by a company called the Clinic Network, TCN. And so this has been a widely reported case because of how it has taken Waxdale and applied it. So the facts of the case is that Mr. Livshin was, or Dr. Livshin was employed by the Clinic Network on what was known as a 3-year fixed term contract. And these contracts are dangerous. And I've always said that they were dangerous. And I've never advised clients to have fixed term agreements. So what a fixed term agreement is it says, we're going to hire you and we guarantee that you're going to be employed for 2 or 3 years in this case. Now, what the employer did in this case is they tried to be cute. They tried to say, okay, fine, we'll guarantee you 3 years of work, but they also buried within the contract a provision that said that they could fire him early and only give him the Employment Standards Act amount, that 1 week per year of service. So lo and behold, Mr. Livshin started working and he was let go with what was otherwise 20 months remaining on the fixed term. And the Clinic Network purported to rely upon that ESA early out clause and just gave him 2 weeks because he had only been there just over a year at that time. And under that legislation, if you're there between 1 year and 3 years, it's 2 weeks. As I said, it's a little bit of an oddity at the beginning. And Mr. Livshin didn't like the idea that he had a 3-year fixed term contract and was fired early, 20 months early, and only received 2 weeks of pay. So he challenged it and we went to court and we fought this. And we fought it on the basis that in that case or in that contract, they also had some of this with cause language. We could fire you for cause, similar to the Waxdale decision. And so the court relied upon Waxdale and struck the ESA only provision. Now, what was interesting in this case is the other side tried to argue, well, hold on a second. Livshin's a doctor. He's a smart guy. And you shouldn't strike this because of some sort of legal issue, because the parties were sophisticated. And the court found that the sophistication of the parties has nothing to do with this contract when it comes to the breach of a statute. You can be as sophisticated as you want. You can be Warren Buffett and Bill Gates. You still cannot contract out of a statute. And so that argument failed, with the end result being the termination provision was invalid, and the court determined that Mr. Livshin was entitled to be paid the balance of the fixed term contract. And as you can see, this was quite a costly mistake because the balance over 20 months was over $300,000. So this drafting issue to illustrate the point on why you need to look at your contracts and why you need to make sure that they're up to date and they're precise, is that this drafting issue cost the clinic network the difference between 2 weeks of pay and over $300,000. And I see these clauses all the time in contracts that predate 2020. It was something that was in vogue for years to have this with cause language in there. So if you go home tonight or tomorrow, or if you're really especially bored over the weekend and you're looking for something to do, pull out your contracts that you might have with your staff members and look through them and see if you see this phrase with cause or just cause. And if that's in there, you should have those reviewed quickly. Because if you have a sale on the horizon, this is going to be a speed bump in terms of getting the deal done. And even if you don't have a sale on the horizon and you're an existing owner and you want to rely upon your contracts in the future, you need to make sure that this drafting error isn't there. Otherwise, as you can see, it may be quite costly. So that's the employment side of things. I just want to end off by talking about associate contracts. Michael touched on this, and Barb and Anthony had touched on it as well, as why they're important. Okay, associate contracts are important for the sale of your clinic. A buyer is going to want to see these in place. They're going to want some comforts in these contracts to ensure that if they purchase your clinic, you know, your associates are not going to go out and submarine them by opening up around the corner or trying to steal all of the patients that they may have a better relationship with than you as a new buyer. So I want to take a case that I argued in the earlier part of this year that is also a very, very important case for dentists. And this case has been cited numerous times since it came out for what it stands for. So in this case, my client, again, was the plaintiff. So you're starting to see a theme that we like to sue people here. They bought a dental clinic. So the history of the clinic was that in 2006, a Dr. Michael Schechter purchased a dental clinic from his father, who was a Dr. Ira Schechter. And Ira continued as an associate dentist at that practice after Michael purchased it. So you had the son, who was now the owner, and the longtime owner of the clinic, the father, had transitioned into an associate and continued to work there under Michael. And then along comes my client and purchases the clinic for a massive amount of money from Michael in 2020. You can see what the dollar figure was there. And I'm not telling tales out of school. This is all cited online. You can find the cases yourself. So the deal was structured as a share purchase. And a very important component of that deal was that Ira, the former owner turned associate in 2006, had to remain an associate dentist in the clinic. And the share purchase agreement specifically required him to sign a new associate agreement as part of the transaction, which included a non-competition provision for a 5-kilometer radius for a period of 3 years. What ends up happening is my client then takes over the clinic, and Ira Schechter, as the associate, resigns in October of 2021. And immediately upon resigning, my client learned that he was now practicing at a clinic that was within the prohibited 5-kilometer radius. As an aside, it came out in the course of the litigation why he ended up within the 5-kilometer radius is he made what turned out for him to be a very costly mistake. Instead of looking at a radius, what he had done was he had put into Google Maps the two different locations of the two clinics and had tried to decipher the distance between them using that. And of course, Google Maps doesn't show you as the crow flies. It shows you a convoluted road between a number of back lanes to get you to the other clinic. So he thought he was outside of the 5-kilometer radius, but he was not. And so my client brought a motion for what's known as an injunction. And an injunction is a very severe, drastic legal remedy that you can get very quickly, and courts typically move at a glacial speed, but this is one of the instances where a court will move quickly. So an injunction is a court order that will stop someone from doing something. They will enforce a contract right there and then. And so what we did is we brought a motion to enforce that non-compete. And as Michael had alluded to when he was speaking, typically non-competition provisions for associates can be difficult to enforce. Just like courts don't like termination provisions for employees, they don't like non-competition provisions for dentists or for any other professional. They don't like to see there being a leash put on competition in the marketplace. The default position is that a non-competition provision for your average everyday associate is going to be unenforceable. But we argued that this case was a little bit different. We argued that because his role in the practice was more than a regular associate, they should enforce it. We said that he had, he was the face of that organization for years before the son bought the clinic. And what we had done in that case is we actually went on the social media platforms for the clinic and pulled post after post after post, showing that even though the son was the owner of the clinic, to the world, they were holding themselves out as a father and son duo. And so he wasn't just your everyday average associate. He was something more to that clinic. And in addition, what the court took into consideration was that the share purchase agreement indicated that the father's goodwill was part of the deal. And how the SPA indicated that was through this provision that required him to sign an associate deal as part of this contract, as part of this sale. He had to sign one. And so the court granted the injunction. And they ordered that he must immediately honor the non-competition agreement, and he must immediately stop practicing at that clinic he had transitioned over to. And of course, for him, that created what I can only imagine was a logistical nightmare, because he had, in the lead up to leaving, arranged to have a number of patients that had seen him for years set up treatment at this new clinic that he thought was 5 kilometers away. And the court ordered at that time and place, you have to stop right now. You can't treat the people who are scheduled for treatment. You can't treat them there. You can figure out somewhere else to treat them, but you're not treating them within the 5 kilometer radius. The court also ordered that he pay costs in the amount of $60,000 on top of what the costs he would have paid to his own lawyer. So for breaching that 5 kilometer radius and using Google Maps instead of figuring out the proper radius, he couldn't practice, couldn't see his patients, had to pay his own lawyers, and he had to pay our client $60,000 in legal costs for breaching that provision. So the takeaway from that case, the takeaway from both of those cases, I should say, the first one shows that the courts are increasingly hostile towards employment contracts. As I said, they will do whatever they can to try and assist employees to get that bigger payday, that common law 1 month per year of service. Every dentist should have their current employment contracts reviewed to ensure they're still enforceable. And if they're over 2 years old, I can almost guarantee you that there's going to be some warts and moles in there that may invalidate the provision. And secondly, with the second case, it goes to show that courts will enforce non-competition provisions. And if you're buying a practice, do not treat the current associate status lightly. As Barb and Anthony and Michael alluded to, these associate contracts are important. So ensure you deal with the associate contracts during the sale process. And what you should be doing, and I'm not sure, that case, the Schechter and the Perec case, is going to ensure that that every associate who signs a contract in the course of a deal is going to be bound by those non-competition provisions, because obviously in this case, the associate was someone more important. Okay, he was the father and he had owned the clinic previously. But certainly in the context of negotiating these deals, if you can build in language as to why it's so important for an associate to sign a contract, the current associate, I think you increase the likelihood that a court is going to treat that non-competition provision seriously, and they're not necessarily going to treat it as a real associate agreement. They're going to treat it as a non-competition provision that was entered into in the course of a sale of a business, which has a much higher likelihood of being enforced. So those two cases are important. Everyone who has employment contracts, as I said, should get them reviewed. If you have associate contracts, you should get them reviewed. And certainly in the context of negotiating any deal for a sale, you should look under the hood and make sure that both of those contracts are up to date.
Perfect. Thank you, Paul. That was great. We have a couple of questions we received this evening. Some of them have been answered already, but we've just got a couple here. I know we've run over time, but we appreciate everybody staying. One quick question would be for Michael Kutner. A question with regards to setting up a DPC. In the case of where there's a husband and wife, owner and a spouse, is it ideal to have more than one person on the DPC for the purchase of a practice?
Yeah, every situation is different. And you have to discuss that with your accountant. If there are two dentists who are married together and have separate practices, you may want to set it up as two separate DPCs, because then you're associating the companies and you're sharing $500,000. So that might get more complicated if there's multiple dentists in the same family. You want to avoid associating the companies. But if you're not making enough money to cause any issue if they are associated, I have seen spouses who are dentists have the same DPC. So it's all for discussion with your accountant to see what works best from a tax perspective.
Perfect, thank you. One other question actually for you, Michael, with regards to corporate tax rate. The question being asked is, isn't combined federal and provincial tax in Ontario for DPCs 12.20%?
That might be right. The amount changes. The amount I may have had in the presentation could be a bit outdated.
Okay, I mean, it was really close. I think they're just curious on the.
Yeah, I think I had 13% or something in there, so.
Okay, okay. Okay, and a quick question for Paul Martin with regards to an associate contract. If an associate is deemed independent contractor and they believe it doesn't fall under the ESA, is that correct?
That is correct. So the Employment Standards Act is just as it sounds, Employment Standards Act. So it doesn't apply to independent contractors. So the ESA, now there is a provision in there that deals with independent contractors and determining if someone is actually an employee or an independent contractor, but that goes beyond the scope of what we're discussing today. Now, interestingly, in that case that I argued, the Perec case, the other side tried to make an argument that a new provision under the Employment Standards Act that had very recently come out applied in this case. And that new provision under the Employment Standards Act actually outlaws and prohibits non-competition provisions in employment agreements. So this is very new legislation. Now there's a carve out within the provision itself for certain levels of employees, C-level employees and management and stuff like that. But for your everyday average employee, so you take a hygienist in your office and you want to put a non-competition provision in their employment contract, that's not going to be enforceable by way of statute now. The other side in that case tried to argue that that legislation applied in the case, and the court specifically said it didn't because he was an independent contractor. And it also did a very wonky thing where it said it wouldn't apply anyways because the contract predated the legislation. And so, yeah, that the point being that most associates and most dental clinics are independent contractors, so it won't apply under the ESA.
Okay, perfect. Okay, I think that's probably all we have time for. I think the other questions we've answered throughout the presentation. So I want to thank everyone for their questions tonight. And if there's any questions that you have for any of the presenters, please feel free to reach out because they'd be more than happy to answer any of your questions offline. And we now have one final poll. So I'll ask Chetan to pop that up for us.
And Kelly, while that poll is coming up, just wanted to let you guys know that we do have the date for our third evening settled. So that is Wednesday, September the 21st, starting at 7:30. And that will be the last evening in this webinar series. And that will be on improving your value now before you sell. So whether or not you're 1 year, 3 years, 5 years or more away, practical tips and ideas and companies that you can engage with to actually improve your value.
Perfect. Thank you, Barb. And just to let you know, the presenters for that night will be Tier 3, Rev Up Dental, Prime Practice, and Henry Schein. So please look out for that registration email. And I just want
Tier 3, I did neglect to mention it earlier. so I will mention it now. So tier 3 does have a $400 off, a full appraisal offer that we can offer anyone who's participating tonight, but that is only valid until the end of the day on June the 30th. So that's 8 days from now, not very long left to take advantage of that offer. It is an offer that was offered in conjunction with the ODA spring meeting. Okay, so that's why it does have an end date to it. So you don't have to have your appraisal, you know, completed obviously by 8 days from now, but you at least have to have had a conversation with one of us if you're thinking of getting a full appraisal done.
Perfect. Thank you, Barb. On behalf of all the participants tonight on our panel, I'd like to thank everyone for attending, and we wish everyone to enjoy the rest of their evening. So have a great night, everyone.
Thanks, everybody. Greatly
Night,
appreciate it.
Take care,
everybody.
guys. Great
Thanks, everyone.
presentation.
Thank you.
Thank you.
Night,